Welcome and thank you for joining us this evening. My name is Matt Bannon, I'm the Customer Group Executive and I'll be your host for this evening's session. Before we start, I'd like to acknowledge countries. WorkCover Queensland acknowledges and pays respect to Queensland elders past, present and emerging. We thank the traditional custodians of country throughout Australia for their ongoing custodianship of land, waters and community. Today's webinar will be run for approximately 1 hour, including time for questions. The session will be recorded and will be available on our website in the next day or so. On the screen are some tips for interacting with us today. We encourage questions and we'll do our best to answer them in today's session. If we don't get to your questions today, we'll do our best to come back to you after the session. We'll also ensure all queries are added to the FAQs, which will be available on our website. And I'll show you how to find some of those resources on our website a little later. Thank you to all who have joined us tonight. We're expecting around 200 people. It's been great to see people interested in relation to what we're going to share tonight. And a big thank you to the ACA and PACFA for assisting and getting us to this point in time. Tonight, what we're going to try and do is give you a bit of a quick guide to WorkCover so that you're ready to go when you're able to provide services from 1 July 2021. We won't be able to cover everything to do with WorkCover because it's a pretty large and broad topic, but we'll do our best to try and inform you on the key things in it to help you get started as we move into the next financial year. So what do you really need to know? So first of all, we'll talk a little bit about how workers' compensation works. So workers' compensation insurance is compulsory for all employers who employ workers in Queensland. And it covers the payment of medical expenses and the loss of wages if a worker is unable to work, and that can be either totally unable to work or partially unable to work due to a work-related injury. WorkCover is basically expertise is significant in relation to return to work and injury management. This is what we do every day. We cover 90% of all workers' compensation claims in the state, and we've been doing this for a long time. And you can benefit from the skills and knowledge we have to assist you in assisting injured workers. And a couple other things you may not know about the traditional workers' comp, and if you've done any work in other states, Queensland has a policy that covers people who are travelling to and from work in certain circumstances, and we call these journey claims. And that's a unique nature of Queensland scheme, and I'll talk a little bit more about that in a second. First of all, I thought I'd do is just take you through the generic sort of claim life cycle of what happens, and it's basically split into 3 areas. First part is around the claim lodgement cycle. So this is where essentially a worker is injured in the course of work and submits a claim for determination. And what we do at that point is we're basically trying to make a decision on the information in front of us in line with the Act to decide whether the claim can be accepted. The second phase of that is when someone is injured and accepted, and the claim then moves into what we call claims management or case management. And this is done traditionally by what we call customer advisors, or you might know them better in other jurisdictions as case managers. This is where we're basically looking to provide early intervention and support for workers, understand what needs are in terms of treatment, coordinating their return to work, working with employers and all stakeholders, including providers, to try and assist people to get back to work as soon as possible and make sure they have a successful outcome. Then you get to the end of the claim cycle where a claim will close, and there are some other stages beyond that where theoretically they can proceed to common law, where a worker then sues their employer for negligence in relation to the injuries they have sustained. And then there is a small program at the end of the statutory claim cycle named Employment Connect. And that is for people at the end of the claim cycle who haven't been able to return to work. And the claim closes in a traditional manner, but we still can offer some services in terms of increasing their employability over time. Now that's a very quick insight into what the life cycle of the claim is, and I'll talk a little bit more about some of the specifics now. Now under the legislation, we have 20 business days to make a decision on a claim. So once a claim is lodged, we will contact treating practitioners for medical information before we determine the claim. Now I call out medical information because for a claim to start, the worker must have seen a doctor, a dentist, or in some circumstances, a nurse practitioner, and they must issue a valid workers' comp medical certificate or a work capacity certificate, as you may also hear it called. That must be submitted for there to be a valid claim. And it's the first point. And if I'm going to give you some advice right away, when you do potentially from start of July, potentially have workers referred to you or come into your practice, the first thing you want to understand is whether they have lodged a workers' comp claim and whether they have seen a doctor first. because that is the starting point of when the benefits can occur, i.e. the coverage of treatment. So the first thing to check is whether they have lodged a claim and they've seen a doctor. That's a key step. Now, once we have that information, what we're trying to do is basically talk to the doctor, the worker, the employer, and understand if we can accept the claim. And we try and do that by gathering information as soon as possible through conversations, information gathering, speaking to witnesses, talking to the employer, talking to the GP or the treating specialist to understand the nature of the injury and how it relates to what's happened in the workplace. Another aspect of that is during that course of that determination process is make sure you're continuing to talk to your injured worker or your worker in front of you and talk to all parties through there, because the more we can talk and understand what's going on, it keeps everyone on the same page, and we can get the claim decided and move through to that early treatment phase. Now let's get a bit more into how the claims are determined. First of all, I want to just point out a little bit of a difference. So when I said earlier that we cover about 90% of all the workers' compensation claims in Queensland, the other 10% are covered by what's known as self-insured employers. Now, there are a number of them, about 25 in total, I believe, at the current stage. And you can find information on these self-insurers on our website. Now, they apply the Act in the similar method that we do, but they do have some different processes. So one thing to check when you're talking, if you have an injured worker coming in, is to understand who employs them as well, because sometimes it can help you understand who you might need to lodge the invoice with or further request for treatment. And again, you can find that information on our website. As I said before, in order for a worker to have what we call a valid application, they must lodge the claim in either what we call a written form. So we actually have a claim form on our website. They can do it online through a claim form. They can do it via telephone. And the application must be accompanied, as I said before, by a workers' comp medical certificate or work capacity certificate. Now, these are all available on our website, and they must be completed by a doctor, dentist, or a nurse practitioner. So it's at that point that a claim gets lodged to us, and we then start to gather information in relation to the claim. The treating practitioner is the key starting point for us to understand what the consultation was about and what the injury is in relationship to. Once we have that information, then we take steps to go through and understand that, and we make a decision based on the balance of probabilities in line with the Act. And I'll talk a little bit more about what they are in a second. And that's based on information supplied by all parties and the medical opinion obtained. Now, who's covered under the workers' comp scheme in Queensland? Well, essentially it's workers. So you must be an individual. That's one of the first steps there. And that's often people who have contracts with a company, but trusts and partnerships or directors are not covered. Essentially, it's someone who's working as a PAYG worker. And there are some other nuances there. Share farmers and salesperson paid in wholly or partly by commission. Now, I'm not going to spend too much time on them because they're not the norm. But the key thing is that they must be a worker by the definition. So we make a decision on that based on information for us. And then if they don't meet that criteria, then the claim isn't eligible at the first end. It doesn't really matter then about the injury. If they're not a worker, they won't be covered under the Act. And then we have a look at what's actually gone on. So what is an event? Now, these are all set out in the Act, and you can read it on the website. It's about 600 pages, so I don't think you're necessarily going to pour through all of it, but I'll highlight some key sections that are going to be interested to you. Section 31 talks about what is an event. So there must be an event, something that's resulted in injury to a worker. Now, that can be something that is a latent onset injury, something like mesothelioma or asbestosis or silicosis. It can also be something that builds up over time, or it can be something really specific that happens in a discrete event. It can be continuous or repeated exposure. So as I said, it doesn't have to be just one thing. It can be a series of events over a period of time that leads to an injury to a worker. And it can be one or multiple injuries that result. So it doesn't have to be a single injury. It can be a number of injuries that can arise from an injury that happens either immediately over a period of time. So as you can imagine, in a work environment, you can have someone who has a very simple low back sprain right through to a multi-trauma injury where there are multiple injuries sustained, for example, in a car accident or an industrial accident. Now, once we've established there's an event, we have to look at then what is an injury. So the definition of an injury is under Section 32. We look at two types of injuries that are covered at a high level within the scheme. First of all, there are physical injuries. And essentially what we're looking at doing is, was the injury to the worker sustained out of or in the course of employment if the employment is a significant contributing factor to the injury? And we also cover mental injuries or psychological and psychiatric injuries as they are referred to in the Act. And this is the same circumstances where we look at whether employment needs to be a significant contributing factor to the personal injury. Now, previously the Act in October 2019 said it must be the major significant contributing factor. The definition is aligned now to physical. There is some nuances within the mental injury provisions where injuries that are sustained arising out of what is known as reasonable management action taken by an employer. And reasonable management action covers things like demotion, redeployment, retrenchment, discipline. So if an injury is deemed to arise out of that, and the employer has done what is known as reasonable management action and in a reasonable way, that will exclude the claim from being accepted. And that comes down to fact. So the onus of proof is on the worker to demonstrate that the employer has either acted unreasonably or done that reasonable management action in an unreasonable way. And it's a two-tier test. So when you'll have clients or workers come into you to see you, some of the information they'll share with you will be about the facts and circumstances that have happened in the workplace or over a period of time. The key to understand is that we will make the decisions around what that information is. We'll talk to the doctor to understand what the reason for the consult and what his or her belief is around the cause of it. And then we'll try to understand with the employer and the worker the facts around that, and if the circumstances can be proven or otherwise. But as I said, if it identifies that it's arisen out of reasonable management action in a reasonable way, the claim won't be accepted by an exclusion criteria that sits under 32.5. Now, I talked a little bit about a journey claim. I thought I'd just bring this in here because it's something that's unusual and unique to Queensland. So this is basically when someone is on a journey between their home and their place of employment. It also covers when they're on a journey between their home and a place of training they're expected to attend on that certain day. It can also be when someone has an existing WorkCover claim and they're injured travelling to and from medical or rehab treatment, so we cover them in that space. And also if they're travelling between two jobs, so travelling from one employer to the other. So in that circumstances, there still must be an event, so obviously some sort of car accident or incidents that occurred in that space. They must have sustained an injury, but it doesn't necessarily need to be a significant contributing factor. It just has to sustain an injury because, as you can imagine, driving in a car has nothing really to do to work other than just the fact that you're driving to and from work. So we just need to establish that there's been an injury arising from that event on a journey that's accepted, and then the claim is accepted. The variation on that is that has no impact in terms of the employer from a cost or premium perspective. So it's a little bit of a coverage for workers without the penalty to an employer potentially with the cost of that injury. Now, I talked about the type of injury. If you talked about physical injuries, we talked about psychological or mental injuries. Industrial deafness is also covered. For industrial deafness, it can be sustained for sustained periods over a working life in noisy environments. We also cover fatalities. Unfortunately, people do die from work-related injuries, either through direct or following injuries. And as I mentioned earlier, we cover latent onset, so things like asbestosis, mesothelioma, silicosis, certain cancers for firefighters, and more recently, you may have seen in the media, there's new presumptive laws for PTSD. So as of the 20th of May, PTSD is now a presumptive injury. And essentially, if you are a first responder, i.e. a fiery, police officer, ambulance officer, correctional officer, and certain other mine rescue officers, child safety officers, if you work in that profession and you sustain a psychological injury and it's PTSD diagnosed by a psychiatrist, the injury is assumed to be accepted from the front end. So it's a new thing that's live to us from the 20th of May. Traditionally, these type of claims are accepted really quickly anyway because they're generally related to trauma based over a period of time or immediately, but it's something to be alive to that's in the environment as well. Now, for you, that won't necessarily mean anything other than just checking again that they've lodged a claim and have seen a doctor, and then I'll explain a little bit more where you'll fit into some of that early intervention while the claim is being determined. So part of the reason why we've come to look to add counselling and psychotherapy services to the broader Queensland scheme is the trends in relation to primary mental injury claims that we are seeing across the scheme. Now, this table here sets out the entire scheme, so it includes us and the self-insurers. And it sets out the general trends around statutory claims, payments, cost per claim. And in the dark blue, you'll see the mental injury claims. And you can see while a smaller group of claims, they are significant costs in terms of the cost per claim. They take a lot longer to return to work, on average nearly 3 times as much, and they don't have as good a return to work. So we know that there's an increasing prevalence in the wider community around mental injury and illness. We've also seen the same trends over time across the workers' comp scheme. And what we found more recently is the need for early intervention services and access to that has been hard. Post-COVID, the access to treatment from psychologists and other counsellors is difficult at the best of times. With the expansion within the Medicare programs and wider access, telehealth, etc. We found the real need to have more people who can provide expert services. Hence why we've introduced counselling and psychotherapy to the mix, just to allow that extra coverage and early access for workers to get the services they need right up front and ensure they start on the right path from the word go. So it's a pretty broad area. It's not a bigger part, but the thing I'll talk about in a minute is where we'll sit. It's not just primary mental injury claims where we have you involved. There'll be some extra areas where you'll pop into the mix and where you'll be able to provide services to the injured workers. Now let's talk a little bit about how you can work with us and what we like to do. And we want to try and make sure that your entry to the scheme is, you have the best knowledge available. You understand what we're trying to do as an insurer and how you can best work with us and your injured workers. We want to work with you to ensure the worker gets the right level of treatment to support their recovery and return to work. WorkCover is focused on getting the best outcomes for our customers, both employers and workers. And I note that particularly that we have two types of customers. We have an employer who holds the policy and pays the premium, and we have the worker who's employed by the employer who is covered when they're injured. So we have two customers, not just one. Our priority is to ensure the workers receive timely treatment and rehabilitation services to help their return to work, and the treatment is at a fair and reasonable cost to minimise impact on employer premiums. As alluded to before, this is not taxpayer money. This is actually premiums paid by employers to cover their workers. So the costs incurred on a claim are caught into their premium down the track, depending on the size of the employer. So it's not, there's some misconception that this is actually a tax or taxpayers' money. It's actually premiums paid by employers. So costs, we want to make sure that we're balancing the needs of both parties by ensuring early access to treatment to get better outcomes and making sure we're paying fair and reasonable and the appropriate amount of treatment so we can balance those costs that go through to an employer's premium. So I guess this means that really we're about working closely with not just workers and employers, but obviously the medical and allied health industry as a key stakeholder here. The influence you can bring and the treatment and services provided can certainly assist us to help injured workers get back to work sooner and deliver better outcomes. As I said earlier, we're very much the claims experts and return to work experts. This is what we do every day. We want to be your trusted guide throughout this process. We want to partner with you to assist you to deliver great outcomes for your workers that you're treating. And we really want to work together closely. So getting to this point, we're having you ready to enter the scheme has really been about talking to the ACA and PACFA closely and understanding what you guys do and how you can best fit into our scheme and make your entry successful right from the word go. Now, how do we approach what we do in terms of claims management? We like to call it our tailored care and support approach. And on the right, you'll see the claim life cycle we talked about. Different workers will have different roads to recovery, but the destination is always the same, to get the best possible outcome for each person and return them to some sense of normality. Some workers need more care and support if their injury is more severe or their recovery is longer. Some workers only need support from time to time, so we try and get out of their way. We work with treating providers, employers to support the worker during their recovery, and we tailor that needs based on what we see in front of us. Do we know that in terms of the risk of prolonged recovery or delayed return to work, we need to ensure that the worker is coping post their injury? It's one of the key risk areas for us in terms of someone not returning to work soon or having a protracted duration of a claim or ultimately potentially not ever getting back to work. We want to make sure they get access to early treatment, and that's where you come in. We want to ensure there's adequate support from the employer. So not only is it important to have the worker coping with following their injury, but it's also making sure the employer is providing the right level of support to the worker in terms of engaging with them and supporting them back into the workplace. We know that if we don't get these two areas right, it can lead to prolonged recovery and durations, and naturally that's never good for anyone. So where do you sort of fit in? So conceptually, you can see the same time cycle as, so life cycle of the claim. We see you coming in right from the very word go. So once a claim has been lodged in this early determination phase, there were changes in the Act back in 2019 that allows coverage of treatment in this phase of determination. So we see you being an active player in the early intervention support of workers. And this is as soon as the claim is lodged and it's a primary mental injury claim, we are able to fund services while we're making that. And that covers psychology, psychiatry, and I'll talk a little bit more about that, and counselling, obviously. So we see that as a very big focus area for you, being able to treat the worker right from the word go when they walk into your practice after they've seen a GP or a treating medical practitioner and they have an injury or illness or incidents related from work, and you can provide that level of support right from the word go. We also see that once the claim is accepted, you'll be involved on those accepted primary mental injury claims as they continue through the life cycle of a claim. There's also other areas where we'll have people who have accepted physical claims that will then start to require some adjustment to injury counselling as they're not coping with their injury. And this is where we'll see another area you may come into where you can provide that level of support and assistance to a worker as they're learning to cope with the recovery or the return to work aspect or the nature of this or severity of their physical injury or injuries. And then we also have the third phase of that, where essentially where we do have the accepted physical claim and then an accepted secondary mental injury claim. So for example, someone could sustain a simple back injury within the workplace, but then over time, due to various factors, develops an adjustment disorder. And again, that's where we see services provided by counsellors and psychotherapists to fit in as well. So you can see that your influence can be right from the word go at the start when the claim's been determined, supporting the worker right at the front end and getting them set up for success, and assisting them as they work through the claim, whether it be primary or secondary to a physical injury, and right through to claim closure and hopefully a successful return to work. Now, what I want to take you through is some of your responsibilities. So to ensure a worker receives the right level of treatment support their recovery work, we have to make sure that we have the right providers providing treatment within the scheme. Now, currently there are two types of providers in general terms who can provide services to WorkCover. There are registered providers. So these are people who are registered under APRA. So for example, psychologists, physiotherapists, occupational therapists. But we also are able to allow non-registered providers, those who are not on APRA, to provide services. And examples of those who currently exist are people like rehab counsellors, exercise physiologists, and now yourselves. Now, the entry requirements we've decided on based on consultation with PACFA and the ACA, as well as looking at other jurisdictions, is you must be a full clinical member of PACFA or level 3 or 4 member of the Australian Counsellors Association. Now, we appreciate that this may mean that some members may not be able to provide services at this point. And it may be that you have previously provided services in small pockets where we've allowed it for various reasons, and you're no longer able to do that. All I can say is that we'll continue to monitor and review as you enter the scheme, and we'll keep talking to ACA and PACFA about what that looks like and whether we need to adjust the level or the minimum entry levels. We've based this entry level on what New South Wales scheme Syria have done and have had in place for a number of years. But I say this is a starting point, and we're happy to continue discussions with the associations of what this means in terms of being able to provide services. We want to make sure that we have the right people at the table at the front end, and we can adjust as we go along. The other thing I want to point out to is that there is a document that you will find within the table of costs on our website, and I'll talk today a little bit more. It's called the Clinical Framework for the Delivery of Health Services. So this was developed by the Transport Accident Commission and WorkSafe Victoria a number of years ago, and is supported by all workers' comp jurisdictions and across the country. And we adopt that framework based on the following principles. And you'll see through the table of costs when you see it eventually, and we want to abide by these principles. So as a provider, we're expecting you to understand this and apply this in your approach. So that includes things like measurement and demonstration of effectiveness of treatment, making sure you're adopting a biopsychosocial approach, which you all understand, empowering the injured worker to manage their injury. So we're trying to avoid passive therapy. We're trying to encourage people to self-manage, be empowered, and take control of their injury and work towards their recovery. Making sure we're using goals that are focused on optimizing function, participation, return to work. So we don't want to do this treatment that just goes on without any goal. We want to have defined goals and plans to work towards the return to work outcome, or in certain circumstances where they can't return to work, other alternatives, i.e. host employment, or if possible, maybe there isn't a return to work. And we want to make sure that the treatment being provided by any provider is based on the best available research evidence. So that's up to you as the clinician to apply best practice evidence within your own domain. And we expect that of all providers. We're not going to tell you what that is, because we expect as a psychologist or a counsellor or a physio, you know exactly what that is, but we expect you to apply that in your own practices as you go along. Now let's talk a little bit about what sort of things we can help you support your entry into the scheme. So on the right, you'll see the front page of what is going to become the counselling and psychotherapy table of costs, and this will be effective from 1 July 2021. So what I'm going to do in a minute is just take you through a look at that. I'm also going to just take you through a couple of pages on our website and just show you where a few bits and pieces are. The table of costs is essentially your baseline key document. It's the most important thing you can look at and review in terms of providing services. It sets out the item numbers that are applicable for services and the maximum fees payable for those services. It sets out service conditions and exclusions. It also talks about approvals. It also goes through guidance on how payments work and invoicing. And as I said, some of that information is embedded in the table of costs. It is also on our website and you can see more of that. So what I'm going to do now is just take you through the table of costs quickly. Now, this table of costs will be published next week, so we'll make it available for you on the website. And I'll show you where this will be located on the website. We've just rebranded all our table of costs. We do an annual review of table of costs every 1 July, and we've refreshed them in our new style. They're a little bit different today previously, but for you, you won't have seen them before. And I'll show you where you can see some examples of past table of costs if you want to have a look. And I'll just show you exactly what we've got here. So we've established a couple of simple consultation codes. So we've got initial consultation for the services, and you can see the fee rate there, and it puts some descriptors around what's expected. That's the initial consult. We have subsequent consults, communication fees, and that's probably something different that you've probably not experienced before in providing services. We actually will fund communication time. We want to talk to you, we want to pay you for your time. And I'm not going to spend a lot of time going through each of them, but you can see we will pay you for your time to talk to us in relation to their treatment and progression of their plan. Not for administrative stuff, but we'll help you work through and pay you for that valuable time when it helps us move the claim forward. We've also got things around case conferencing, which we will pay for. We do request reports from time to time, and we'll fund that as well. And we do allow travel in certain circumstances where people have to travel outside of their practice. So again, there's a number of different bits and pieces. What I will say at the end of this document is lots of more detailed descriptors, which goes through this information in more detail and explains some of the information you'll need to know. It also steps through the guidelines for services, invoices, and payments. Now, as I say, this can be found on our website next week, but what I'll do is I'll just show you where you can find some of this information now. So this is the WorkSafe website. It's a joint website between the Electrical Safety Office, Workplace Health and Safety Queensland, WorkCover Queensland, and it's basically a new refreshed website. It looks very different. For those who may have come to this website in the past, it was a little bit less friendly. This is much more easy to use. So for example, what I'm going to show you is where to find fees. You can search directly in here, or you can actually roll down to the bottom of the page. You can see all the various articles. And down the bottom, you'll see fees and under service providers, and you can click onto the fees. So in this fees area there, you can see basically this is where we store fees for all providers. We have medical fees, radiology fees, current allied health fees. Now, this is where, when you expand this section out, has the existing fees that are current through to 30 June 2021. And you can have a look at any one of these in the past and see what they look like. What will happen from next week is we will publish the fees effective from 1 July. And then when 1 July kicks on, they'll become the current, and the old fees will move across to the right in the past fees section. So please feel free to have a look through them if you want an example. But as I say, we will let you know when they're live, and you'll have a link to see your current table of costs, which will appear on this website very shortly. The other area we can take you through is looking at working with WorkCover. Now, this information has lots of stuff that'll help you understand what to do and what your responsibilities are. It talks about generally around all sort of service providers. It tells you how to register as a provider, how to invoice us. Provider Connect, which is our online services. It means you can lodge invoices online, you can monitor your invoices, it's a much more efficient way than having to fax them into us. Again, I'm not gonna have enough time to spend time talking through that, but please have a look at this, and we'll add some links to the information on the way out so you can see this stuff. I will just take you to the register as a provider section, because I know that's going to be one of the questions that'll come up. We do need you to register, but not register in the way you think. It's not like an accreditation process. What we'll get you to do is, rather than rush out to try and get us to register you as a provider, all we need you to do is, when you provide your first service, is you send the invoice to us. And what we'll do, we'll register you at that point in time. So what we'll do, we'll have a look at your we'll probably make contact with you to look at your qualifications in line with those minimum requirements, and we'll set you up in the system, and then we'll set you up with EFT details and make the payment to you based on that. So you don't have to rush to us now before 1 July and register. That'll happen at the time you provide a service, and we'll take care of that for you at the time. The other thing I thought might be interested to know, and you can have a search for a website if you type in mental injury treatment guidelines. We developed this in consultation with the Royal Australian New Zealand College of Psychiatrists and the Australian Psychology Society, the APS, back late last year. We released it in November 2020. And we have other guidelines that exist on our website now in relation to spinal surgery, upper limb surgery, lower limb pain interventions. But we felt there was a real need to introduce something that related specifically to mental injury treatment guidelines. It includes everything from the way of our approach, certain treatments, evidence-based, and you can have a look through that yourself at your own leisure. It's designed to be a roadmap for providers and workers and our customers to understand what we do and don't approve and how much we approve. We're really determined to ensure we get the right level of care for workers. And this is an evolving document that will continue to refresh over time. So do have a look at that. It's available on our website. As I say, search for mental injury treatment guidelines and you can download that and have a look at it. As I mentioned before, in the early intervention phases, so when a claim is being determined, there is support now offered for workers who suffered a mental injury. We have to take all reasonable steps. It's required of us under the Act to deliver those support services to someone who's suffering from a mental injury before the claim is decided. Now, in the past, we weren't able to do that until the claim was decided. So this is a great outcome in terms of legislative change. It's significantly assisted people to have that access to treatment while they're waiting for a decision to be made. And it certainly reduces the severity, duration, and hopefully the recurrence of mental illness. Now, those are injuries applied from 30 October 2019. That won't bother you now because all injuries are generally lodged much later than that. But the things it covers include GP appointments, counselling or psychology appointments, psychiatry appointments, psychotropic medication, mediation services. So occasionally we are required to look at mediating between a worker and an employer, and we can do that. And it does associate some costs with attendance at hospital emergency for outpatient. It does not cover inpatient programs that might be in another facility. There is another service that I'll talk to you about quickly. This is called the Workers Psychological Support Service. It is an independent support service that is set up by the Office of Industrial Relations, and it's supported by currently by the Queensland Council of Unions, hosted. What this is an independent service where there is a social worker who is available to provide guidance to workers during the course of a claim, during the start of a claim, while a claim being determined, while a claim is accepted, and even after a claim has been closed. And what this social worker does is connects people to services and information that might support them. They don't actually provide services directly, but what they do are connector to try and connect people with things like financial guidance or where to provide the right level, to access the right level of services and other things like that. So it's something that's been in place for 3 years now. It's been very successful. We directly refer people to that as a need. And it's been reviewed more recently and looks like it'll be extended over the next couple of years. So it's just something I thought I'd make you aware of. Again, that's available. We can provide the link to that if needed. But it's something we offer to workers and provide that guidance, and they can go and seek independent support as needed. Now, I'm going to talk a little bit about the research quickly, just so you understand where we come from, the principles of why we do what we do. For those who don't know about the health benefits of good work, this is a consensus statement that was developed by the College of Physicians and Occupational Medicine. About 2010, 2011, it's been refreshed over a number of years. What we do know is it's evidence-based in that the longer someone is off work, the less likely they're ever going to return to work. And some of the stats show that if someone's off for 20 days, 70% chance of return to work. And 45 days, 50%, 70 days, 35%. So what we know, and this supports, is that the sooner we can have someone back at work, either recovering at work or back at work on alternate duties or alternate hours or in an alternate role or even in a host employer if we need to do that from time to time, is super beneficial in terms of being successful long-term outcomes. If someone is off work for 12 months, it's unlikely that they're ever going to return to work based on what we see. So the sooner we can have someone engaged in work and returning to work, the better. And we are a signatory to this consensus, and we support it as part of our mantra. So you'll hear our customer advisors talking to you about what are we doing to support people return to work? How is your treatment facilitating that? How can we look at this gain to get them back to work? What are we doing to do that? How can I help you work with the employer to bring this person back to work sooner? What do we need to talk to the GP about certifying them to go back to work? You'll see that we will apply this approach in every circumstance where we can, noting that we're going to look at the circumstances and understand where they're at in their treatment cycle, and you'll be a key player in understanding how we can influence this at the right time. So how can you help us realise the health benefits of good work? So I suppose it's really about working together. we want to work with all parties collectively. So we're looking at the worker. We want to make sure we've got regular, honest communication. We want them actively participating in their rehab. We want them to be part of this process. It shouldn't be something that's done to them. It's something that they're part of. They should be empowered to be part of that. We want to be working closely with the employer. We want to make sure they've got a safe place of work. They want to make sure they've got enough information to understand what's going on and they're reporting injuries early to us. We want to talk to them regularly. We want to have them meeting their obligations under the Act, but also doing the right thing to support return to work. And we want them to offer those suitable duties. And our job's in the middle, trying to work with providers and to try and facilitate that as best as we can. And we know that you're a powerful influence in terms of getting people back to work. So the sooner we can talk to you and work with you on these things and assist in that early discovery of positive return to work and promote that as a benefit, the better we all are. Just some practical advice. Please keep talking to your patients or your workers, as we would call them, and reinforce the benefits of work. That work is good for you. Work is not the end stage of your rehab. It's part of your rehabilitation. It's a therapeutic intervention. It's part of your treatment. And waiting to recover often delays recovery. So waiting until you're fully recovered doesn't necessarily help you to actually recover. It's better to actually start that recovery journey through work as opposed to being away. And you'll know this from your own experience, that someone who stays at work from a long period of time can have significant secondary impacts, isolation, poor health, and other outcomes that aren't necessarily great for the long-term health and recovery of these people. Just a couple of key takeaways too. If you remember to talk to us, we can really help. As I said, we're happy to pay for your time when you talk to us. We know you're busy, you have other things to do. You can invoice us for that time. We want to encourage that communication and we want to have that open dialogue to help us understand. Remember the research, as I say, every claim's a little bit different, every injury is a little bit different, every worker, every dynamic, every employer is a little bit different. But we know that the research demonstrates if we can keep someone at work, recovering at work, or get them back to work sooner rather than later, it's in the best interest of everybody. And just remember that we want to work together. You have that clinical knowledge that we need to assist us. We have that return to work knowledge. We know how to do this really well, and we can be that assistance to you getting that information from the doctor or working with the employer to reduce the barriers to get someone back to work. So I suppose for us, it's really about working together to support the worker back to their job. So what's next? So as I said before, we will publish the Counselling and Psychotherapy Services table of costs, and it'll be available on our website next week. Those services and fees are effective from 1 July 2021. As I said, there's no need to register with us right now. This can happen when you submit your first invoice. What I would encourage you to do is have a good read of those table of costs and understand what's going on in that, and it talks you through how to invoice and all the necessary requirements for you to deliver service for us. And again, we'll send some links in relation to those key website resources that'll help you understand how to bill, how to invoice. And again, some of that is covered in the table of costs, but there's some other information you want to familiarize yourself or your practice manager or assistant staff to get them through that. Now, you can stay up to date and register for fee updates. There's a link there that'll take you to an ability to subscribe. And each time fees are updated, you'll get an email alerting you around that. So that'll be live, a live link in the PDF when we send this out to you. So that's really all we wanted to cover from a high level. What we want to do now is see if we've got any questions from the audience and do our best to try and answer as much as we can. We've got a bit of time up our sleeves. If we don't get any questions answered, we'll make sure we cover them later on and we'll send them through to you later. One of the first questions we figured it might be one of the things you will ask is around how do you register? So again, as I said, there's no specific process other than lodging your invoice with us immediately, and we'll take care of that for you at the time. And that'll mean we'll contact you, ask for information in relation to your qualifications, and we'll set that up for you with a P account, we call it a provider account number, with your bank account details, and then we'll pay into your accounts through that process. It's a very simple process that we will do for you. You just have to bring that invoice to us, and then we'll take care of that on the spot. Now, I'll just see, we've got a couple of questions from the audience. Just have a look as we work through them. One of the questions is in relation to, can a psychiatrist initiate a claim? Yes, that's actually the case. So as a medical specialist or medical practitioner, a provider, being a doctor, can lodge the claim on behalf of the worker. So A worker can attend a GP or a psychiatrist or another medical specialist, and by completion of the WorkCover medical certificate or the work capacity certificate, they can lodge that directly with us, and that will lodge the claim on behalf of the worker. In some cases, workers will attend a public hospital, and a public hospital can lodge the claim on behalf of the worker. What we do in those circumstances is we need to check that the worker wanted the claim to be lodged, so we'll contact the worker up front to establish that they were happy to have the claim lodged, and then we'll proceed forward with the claim from those steps. We have to be mindful that the worker wanted to proceed with the claim, and they don't have to proceed with the claim if they don't want to. We'll just confirm with that before we start the official steps. There's a question from the audience, is there an option on a case-by-case for someone who isn't a level 3 member? Yeah, that's a good question. In the past, we haven't had a particular restriction on who could provide services, because traditionally before July 1, you weren't able to do it. We've had circumstances where, for various reasons, we've had to allow it. I would suggest at the current point in time, it's a no. We need to stick with the baseline entry we've got there in terms of level 3 or 4 from an ACA member. However, there will be circumstances from time to time where we may need to address certain needs because of access and bits and pieces. My suggestion is, before you provide the services in those, please check, and we can address that on a case-by-case basis. But at this stage, our position is going to be it's level 3 and 4 or a full clinical member with PACFA. Now, there's a question here about, can a counsellor provide counselling services if the counsellor is not yet registered with WorkCover? You can actually, but what I would suggest is the first step is to make sure that they have a workers' comp claim lodged and they've seen a doctor. That's your starting point. Once you have that, that allows you to provide the service. Once you've invoiced, then we'll register you at that point. So you can technically provide the services if you meet those requirements, but as I said, you want to make sure you are a level 3 or 4 or full registrant. Otherwise, we won't allow that service to be paid. So that your guidance is to really check that you meet the requirements, provide the service, check that there's a claim in place, I should say, and that's the best way to guarantee. Now, if there's not a claim lodged and you provide a service to a worker, the risk is that then that bill's not going to be paid by us. So you need to make sure there's a claim. Now, what we tend to do with most claims with workers is, when the claim is registered, we tend to send them an SMS with their claim number, and you can ask the worker to see if they have that. Often they'll have it as a text message. They also have an app called Worker Assist, which has details of their claim, and they can show you that they have a claim in with us at the moment. You can also call us on 1300 362 128, and you can check if a claim has been lodged. That also can assist you in that process. So guidance is always check and be careful before you do that. The last thing you want is to not have a bill paid. One of the other questions here is, if a claim is not accepted, will the worker have to pay back services already provided? No. So in the case of, in your cases where you'll be delivering mental injury services to mental injury claims, in that early intervention phase, regardless of whether the claims are rejected, we cover those services. We don't go back and chase the claim later or the claimant later for that money. So yes, we'll cover in the early intervention phases. However, if the worker receives treatments outside of the claim liability period, i.e. when the claim is closed, then we may not pay for those services, in which case then the worker would be liable to pay those services, and that would be an issue between you and the worker and as a provider. It's very rare that this happens. So again, the key element there is to communicate with us and understand what's going on. If unsure, check with the worker. If in doubt, check with us and see if the claim is still open or ongoing. We do our best to try and notify the providers when the claim is accepted or rejected or the claim is closed, so we don't run into this trouble where someone might be having to repay, have to cover fees outside of that. We're very mindful of that. We're very keen to make sure that no one gets stuck in that situation. There's a good question here about how is confidentiality maintained. Got a little screen thing here, just for a tick. There's a question about confidentially maintained. Well, we're subject to normal privacy laws, as are you as a provider. A worker who lodges a workers' comp claim with us, an application for compensation, has to agree to our privacy terms, and that allows us authority to speak to the individuals who might be treating them, i.e. a doctor, a provider, a medical and allied health. So that's part of the arrangement with us. Now that is set out on the claim form, but also we play that as a privacy statement to workers. Now, for them to have a claim, they have to agree to that. We don't share information with employers. It's not necessary that's only relevant to their rehab and return to work. We don't share information otherwise. We only collect what's relevant to the claim, and we only utilize that information in relation to the claim. The last thing we want to do, covering, you can imagine some of the information we keep and collect, we have to be very careful what we do with it. So we have very tight restrictions, very clear pathways on what we do and don't release. If in doubt, we are required to get the worker to fill out an authority, and we can issue that to necessary providers who have concerns about whether they want to speak to us or provide information. And again, we can deal with that on an individual basis if you have concerns when that comes time, if you ask for information. There's a question here about how do people find you as a provider, and how do GPs know that you're a provider? Yes, this is an issue for your own self as a provider, how you market yourself. From 1 July, as we stated before, it'll be available on the website, knowing that psychotherapists and counsellors who meet the requirements are able to provide services. My suggestion is we don't advertise to the wider scheme. That's relying on you as a business owner or a practitioner to build those networks and relationships with your GPs who may refer you for services. That's really something that comes down for you. So we don't have a register anywhere of people who are approved providers. The only difference with that is when we have procured panel providers. For example, we have IME doctors, independent medical examiners. We have return to work services providers who provide certain services to return workers back. And those are published externally. But everything else is generally down to word of mouth and the relationships you have with local providers in your area or your network. Now, in terms, there's a question around GST. In the table of costs, it talks about guidance around that. All the fees are excluding GST. The best sort of guidance for that is essentially you need to seek guidance from the Australian Tax Office or your own tax advisor and understand where you fit as a provider. We can't really provide you advice on whether you should or shouldn't charge GST. That'll come down to something that maybe the ACA and PACFA can assist you in terms of what that means. But every provider is a little bit different. So I'd seek some individual tax advice on that. And as I said, maybe the association can assist you with some of that guidance as well. Again, there's a question here around connecting, how do we pitch to employers that you're available? I suppose it's a similar thing. So we do find that employers from time to time develop relationships with certain providers to provide that early intervention services, similar to where you have EAP programs in place. Again, that comes down to you building your own networks within that. Again, a worker has a choice of who they go and see. So we don't refer for treating services. The worker has the right to see their own GP, their own specialist, their own allied health provider, whoever it happens to be. The only time when we direct referrals is when we're doing independent examinations with doctors or specialists, or where they have to go to the medical assessment tribunal and other areas. So again, it comes down to you building those networks with your own local employers or people who may be patients of yourself or within your medical practice or wider multidisciplinary practice, depending on how you work. Again, that comes down to just building your own brand and network around that. We don't, as I said, we don't necessarily promote that. But again, you can develop some strong relationships there that will help you with your referrals. But again, that's not a role we play. We have to stay impartial in that space. I'm just thinking if there's any other question I'm looking through. We've had quite a few come through. No, there's a question here again, just further on the confidentiality. So do employees, as in, I assume that means workers, need to sign a form of confidentiality release so we can talk to you, GP and anyone else? Or is it standard that we can talk to all these parties without confidentiality release? Look, as I said, from an insurer perspective, we, as part of having a claim, we have the right to speak to those parties as part of having a claim. If a worker doesn't allow us to speak to those parties, then the claim can't proceed. So we have an authority that's built into that claim. In terms of you talking to other providers and bits and pieces, my guidance would always be as a provider that you speak to the individual involved and seek that they're comfortable for you to talk to the GP, for example, or in this case, your employer if need be. So again, that's working with your individual worker to understand what they're comfortable with. And if you're uncomfortable around that, you can sort your own information out to have that dialogue and what you feel comfortable to protect yourself. I can't really give you guidance on that because we have an authority to do that. and you can ask that from us if you need it. But in most cases, it's built into the fact that they have a claim. When you're working between different employers or different insurers or different providers, you need to just be clear with the worker what you're doing and seek that counsel from them and be clear on what you're able to do. And yeah, there's a clarification point here. Can you work with a client prior to a WorkCover claim being approved? Yes. So, with a mental injury claim that's been lodged and has seen a doctor, you need to that's the opportunity for you to provide under the Act treatment services in an early intervention phase. Prior to them seeing a doctor or having lodged a claim, you can provide services to them, but they're not going to be covered by us. So that the starting point is seeing a doctor, bring a claim with us. That's your trigger point for them to walk through the door, and you can provide those services to them. And it can be delivered while we're deciding the claim. Once the claim is rejected, though, in that circumstance, then the provision for services stopped. If the claim is accepted, the services can continue through as the claim progresses. A good question here, if you're already providing counselling through WorkCover now, so there's a few select providers over time who've been able to do this. Can you continue to provide services? Yes, you can, those who already have provided services. What I would suggest you do is from 1 July, just recheck that you meet the necessary requirements again. And you can do that by ringing us on the 1300 number if needs be. But if you meet the necessary requirements of level 3 and 4 or a full clinical registrant, you should be okay. My suggestion would be probably just to make sure we have that information on file so it doesn't ever come up. And that can easily be supplied to us. And again, you can contact us and we can sort that out for you. I've got a question here. I'll just say, what do I do if I believe the worker is burnt out, emotionally and psychologically exhausted by the work, and that a return to work could be contra-therapeutic? Now, that's a really good question. I suppose the circumstances there is when you're seeing someone in relation to a WorkCover claim and you're seeing things in relation to their recovery or how they're managing their illness or injury, the key point is to talk to us about what you're thinking in terms of the relation to their treatment, how they're progressing, and having a discussion with us so we can work together and understand what's needed. It can very well be the case that it's too soon to go back to work. It can be that there are other pathways to better support them for a return to work. And again, I think the key is to talk to us, and if necessary, you're talking to their treating GP or medical specialist or psychiatrist who might be working with them to understand what's the best pathway collectively to actually help this person progress with their rehab and treatment. Now, it may very well be that return to work at that very point in time is not the right approach. It might be there's some more time required or other things to step through, or a different approach to that. And again, one of the options may be to undertake a case conference with us, which we can facilitate. Now, that's something we have to approve first of all, but we find that's a very useful way to get potentially yourselves, a treating psychiatrist or GP, us in the room, sometimes the worker and the employer together, sometimes just the worker alone, sometimes without the worker, depending on the nature of the conversation, to try and work through those barriers and understand what's the right time and right place for this and how treatment's going to help progress to that point when they can start return to work. So that's a really good question, and I think I alluded to in some of the slides. Everything is case by case, and we really want to understand what you're seeing from your expertise, how we can best support that injured person to get back to work at the right time and what they really need in terms of the treatment. And that's where we're going to rely on your information and your understanding and your clinical expertise to help us move that forward. Now, let's see if we've got any other questions as I look through. There've been quite a few. Thank you for putting all your questions in. There's a general question about how referrals are assessed. I think I sort of covered that in the slides. We basically need to understand that, first of all, they're a worker, they've had injury and event. There is another provision in the Act I didn't allude to, that there's a time to apply within the Act. So the Act in section 131, feel free to have a look at it, talks about the time to apply. So a worker has 6 months from the time they first see a medical practitioner to bring a WorkCover claim, and that's the time period to allow them to bring the claim. Now, there are some waivers in that to talk about mistakes, reasonable cause out of the state, and some other provisions that are more recent, but essentially there's 6 months time period for someone to bring that through. If they meet that criteria, they have a medical certificate, they're a worker, they have an injury and event, and we assess all that criteria, which is essentially about information gathering. We're talking to the worker to understand what's happened, then we talk to the employer to understand what facts and information they can provide to substantiate what has gone on, and we're certainly talking to the treating medical practitioner to understand the nature of the injury and how it's arisen from work. And when we piece those pieces together, we make a decision, essentially, to accept or reject the claim. Now, what happens when we accept the claim? The claim proceeds forward and everything moves along nicely. When we do deny a claim or reject the claim, the worker is entitled to a written reasons for decision. What happens then is the reasons for decision is provided to them, and they can seek review of that with the workers' comp regulator. Again, that's a whole process you can read on our website, but that's an administrative review of our decision, and the worker gets to submit further information for the regulator to make an independent review of our decision and decide whether they uphold our decision, overturn it, or send it back to us to make with further instructions to make additional steps around that and make a fresh decision. So there are a number of different layers there that go through that. So there's a starting point, an end point, and a review point. So that's sort of how we approach it. And again, you will come across this as we may even talk to you about understanding the nature of the injury as well to help us further flesh out what the causes are of the injury. But again, we do rely heavily on what the treating medical practitioner or psychiatrist has presented to us, given the way the Act is written, that they are the first point of call around that decision. So I hope that sort of summarises how we approach it, but it's a bit more detailed than that, but it obviously gives you a very sort of quick view into what we do. Let's see if there's anything else before we wrap up. And if there is anything we've missed, what we'll try and do is we'll pull them all together and then try and answer them. Here's a really good one I'll try and do just before we finish. If an injury occurs during an interstate travel, which is a really good question, actually. So yes, there is provision. So what we have to look at is basically if a worker who's employed in Queensland and is traveling for work interstate, and in the course of that extended work period is injured, then yes, they can be covered. If they're interstate for extended periods, for long contracts over certain periods, then we have to make decisions within line with certain provisions on the Act. So again, yes, if you're traveling interstate with work or even traveling overseas and it's related to work, that's fine, we'll cover that. Again, we'll look at the circumstances related to that and make a decision based on the information to hand. So yeah, we need to make sure that workers are covered when they're traveling for the courses of work, otherwise there'd be no point in having a claim system for them or a policy. So that gives employers that peace of mind that if their worker is going to Melbourne, for example, to do a short conference or do some contracting work down there, they're covered for the period of time down there. So yeah, and we see that a bit with FIFO workers and other things like that, where they're traveling interstate back and forth and the coverage for that. So there's lots of layers there, but it's a really good question. But yeah, very similar. It's there to protect workers. It's designed to give them that coverage they need. Now then we might wrap that up there because there's plenty of questions through there. And if we've missed anything, we'll try and work through them and summarize them back as part of the flow through. So what will happen from here, basically, we will publish the table of costs from next week and we'll send some information out to you. And then it'll be a matter from 1 July, you'll be effective to be able to provide the services. When you provide your first service, essentially you lodge your invoice and away you go. Now what we'll do is we'll keep in contact with the ACA and PACFA as we transition towards this. And then if there's any other issues and bits and pieces that come up, please feel free to pass them on to them and they can come to us and we can work through them bit by bit. Otherwise, thank you very much for attending tonight. And I hope that was beneficial.